Brett Kavanaugh says he doesn't owe the public an explanation. The justice has one half of a really good idea. Justice Brett Kavanaugh defended the Supreme Court's recent practice of handing victories to President Donald Trump without explaining those decisions while speaking at a judicial conference on Thursday. For most of its history, the Supreme Court was very cautious about weighing in on any legal dispute before it arrived on its doorsteps through the often very slow process of lawyers appealing lower court decisions. There are many reasons for this caution, but one of the biggest ones is that if the justices race to decide matters, they may get them wrong. And on many legal questions, no one can overrule the court if the justices make a mistake. Beginning on Trump's first term, however, the Republican justices started throwing caution to the wind when Trump loses a case in a lower court. His lawyers often run to the court's shadow docket, a once obscure process that allows litigants to skip the line and receive an immediate order from the justices, but only if the justices agree. Unlike in ordinary Supreme Court cases argued on the merits docket, the justices do not often explain why they ruled a particular way in a shadow docket cases. Before Trump, the court was hyper-cautious about granting relief on the shadow docket because doing so often required them to decide high-stakes matters without much deliberation, full briefing, or an oral argument. Now the Supreme Court hands down emergency orders benefiting the Trump administration so often that it's just a regular part of the justice's work. The court was much more reluctant to grant similar relief to former President Joe Biden, a Democrat. Law professor Steve Vladek pointed out in late June, the court granted, at least in part, each of the last 14 shadow docket applications filed by the Department of Justice. Since then, the court handed Trump 2 more victories on its shadow docket, including a major decision permitting the Trump administration to fire close to half of the Department of Education's workforce. Though the Democratic justices frequently dissent from these shadow docket decisions, the court's Republican majority rarely explains why they cast their lot with Trump. At a judicial conference last week, Justice Elena Kagan, an Obama appointee, said that these silent decisions are a mistake. Courts are supposed to explain things, Kagan argued. They're supposed to explain things to litigants. They're supposed to explain things to the public generally. And that brings us back to Kavanaugh's remarks on Thursday, which seemed to be a direct response to Kagan and others who have offered a similar criticism of the court's unexplained pro-Trump decisions. Kavanaugh's argument for silence is pretty good, but only if you assume that the court needs to fast-track every request from Trump. Kavanaugh's case for deciding Trump cases without an explanation is fairly straightforward. The shadow docket is often the court's first opportunity to weigh in on a particular lawsuit, but it will not be the last. Typically, when the court grants shadow docket relief, that relief is only temporary, lasting while the case is being litigated to a final decision. Once the federal appeals court reaches its final decision on the matter, the losing party can seek Supreme Court review of the final decision. And if the justices decide to take up the case in this latter stage, it will receive the full deliberation, briefing, and oral argument that Supreme Court cases have traditionally received. Kavanaugh warned that there is a risk if the court releases a majority opinion when the case reaches them on the shadow docket of a lock-in effect of making a snap judgment and putting it in writing in a written opinion that's not going to reflect the final view. What I don't understand about that, though, is of a lock-in effect. What does he mean of a lock-in effect, though, right? Like if they have the majority on the court, they can basically do whatever they want. Like they can make a decision, they can change precedent, they could change precedent and then the very next week change the precedent right back and change their minds entirely, right? There is no such thing as a lock-in effect, right? It's not like if they make a decision on one of these cases, they can't then go back and change their mind on it. Of course they can. If the majority explains itself, the argument goes, then the justices may become entrenched in a position that is incorrect, and that they would not have reached if they had considered the case for the first time after full briefing and argument. Lower courts, meanwhile, are bound by Supreme Court opinions, even when those opinions are handed down on the shadow docket. So if a majority of the justices hand down a half-baked opinion that is riddled with errors and unworkable legal standards, every other court in the country will have to apply those standards to similar future cases. Viewed through a narrow lens, Kavanaugh makes a pretty good argument. If you assume that the Supreme Court cannot simply tell Trump to wait until after the lower courts are done considering his cases before the justices get involved, as it did for nearly all litigants for most of its modern history, then Kavanaugh is right that these hastily decided cases should often be decided without an opinion. The justices should, at the very least, be briefed on all of the downside risks of deciding a case in a particular way before they issue a binding opinion that makes those risks a reality. Maybe they can't actually go back. Maybe once they make an opinion, I have a feeling like if they made an opinion, they made a ruling, and then for whatever reason they decided they want to change it like a week later, they could just have somebody like fabricate another lawsuit and then they shadow docket their way up to the front of the line. So they effectively can just go back on their word immediately. But the justices do not need to drop everything and race to hand down a decision every time that Trump lawyers ask them to do so. The court used to have a way of screening shadow docket petitions to ensure that only the ones that required their immediate attention received it. It could go back to doing things the way they were done before Trump's rise to power. The Supreme Court explained how the shadow docket is supposed to work in Nken v. Holder, which was handed down roughly a decade before the court turned its shadow docket into a fast-track complaints department for Donald Trump. Nken explained, when a litigant asks an appellate court to block a lower court's decision while the case is still ongoing, it is not enough for that litigant to demonstrate that they are likely to prevail on appeal. Someone seeking shadow docket relief, or its equivalent in a lower appeals court, must also show that they will be irreparably injured absent a stay. Often, appeals courts must also ask whether blocking the lower court's decision would substantially injure any third parties or otherwise harm the public interest. Think of it this way. Imagine that Pepsi sues Coke, wrongly claiming that it is illegal to sell Coke products in the state of Indiana. Now imagine that a trial judge issues an injunction prohibiting Coke from selling anything in that state. This injunction is illegal, and an appeals court should eventually reverse the trial court. But under Nken, Coke may not be entitled to an immediate relief before the appeals court reaches its final decision. The ban on Coke sales in Indiana, while illegal, probably won't cause any irreparable harm to Coke. When it wins on appeal, Coke can calculate how much money it would have earned if it had been allowed to do business in Indiana while the injunction was in place, and a court can potentially order Pepsi to reimburse Coke for this amount of money. Now imagine a different version of Pepsi v. Coke, where Pepsi convinces a trial judge to force Coke to reveal its secret formula for Coca-Cola syrup. Once a secret is out, it is out. So under Nken, Coke should be entitled to an immediate appeals court decision allowing it to keep its most precious trade secret confidential. As Justice Ketanji Brown Jackson explained in a pair of dissents earlier this year, however, the Republican justices appear to have abandoned Nken, at least when the Trump administration asks for shadow docket relief. In Social Security Administration v. AFSCME, for example, the Republican justices ruled that DOGE, the enigmatic White House office that was once led by billionaire Elon Musk, may have immediate access to sensitive information kept by the Social Security Administration. Notably, however, when a judge asked one of Trump's lawyers what harm the government would experience if DOGE's access to this information were delayed, the lawyer did not answer, saying instead that the Trump administration would stand on the record in its current form. Okay, so the way I understand it, if I understand this explanation correctly, they would have to prove that the government will be irreparably injured absent a stay. Okay, they would have to, if they're following the Nken standard like they used to, when the Trump administration comes in, this DOGE, and asks for access to all the Social Security Administration data, and they want immediate access to it via shadow docket relief from the Supreme Court, prior to, them just completely going sycophant to Trump, the government, so the executive and the lawyers making this claim and asking for this request, would have to prove that the government will be irreparably injured absent a stay, that there will be irreparable harm and damage caused by not granting immediate relief. Similarly, in the Trump administration's brief to the justices in AFSCME, Trump's lawyers did not even attempt to argue that it faced irreparable injury without shadow docket relief. Yeah, because you couldn't possibly make that argument, right? You couldn't argue that that the government will undergo some sort of irreparable harm because Doge doesn't have immediate access to all of the Social Security Administration's data, right? You couldn't possibly make that argument in court. And so, so the only way that they could get this passed quickly would be for the Supreme Court to completely do away with the Nken standard of shadow docket filtering. I don't know. Filtering, I guess, is the word you could use for it. The brief devoted only one paragraph to the question of irreparable harm, and it did not identify any injury to the government that could not be unraveled by a future court order. Instead, it merely complained that the lower court order blocking Doge's access impinges on the president's broad authority. Okay, so the Trump administration's lawyers are arguing that the Nken standard is not the standard by which the Supreme Court should filter out shadow docket cases or not. How they mesh with the president's broad authority, right? Basically, how much does it help us in our political goals or not, right? This is purely ideological. And yet the Republican justices voted with Trump, violating Nken in the process. Restoring Nken would not mean that shadow docket relief was never available, or even that it would not be available to the federal government in particularly pressing cases. To understand why, consider Judge Matthew Kaczmarski's infamous decision attempting to ban the abortion drug mifepristone by rescinding the Food and Drug Administration's approval of this medication. The Supreme Court blocked Kaczmarski's decision on the shadow docket, and it was right to do so because cases involving pregnancy are a classic example of a time-sensitive matter where people will be irreparably harmed if the courts do not act quickly. If Kaczmarski's order had remained in effect, many women seeking abortions would have been unable to obtain the medically recommended treatment. Some might have undergone much more invasive procedures, such as a surgical abortion. Others may have been forced to carry their pregnancy to term. These are irreparable harms. Once a woman undergoes surgery, it is not possible to unoperate on them and then go back in time to give them the medication that they should have received in the first place. On the other end of the spectrum, consider the Republican justice's decision in Trump v. Casa, which held that lower court orders blocking Trump's attempts to strip citizenship from some Americans may have been too broad. Though Casa was the unusual shadow docket case where the Republican justices actually produced an opinion that discussed Nken, they brushed off the question of how, exactly, the government is irreparably harmed if someone remains a citizen while this case is being litigated. Casa was the unusual shadow docket case where the Republican justices actually produced an opinion that discussed Nken. So they're willing to discuss the concept of it, right? It's not like they're going to pretend like it doesn't exist. But then they brushed off the question of how exactly the government is irreparably harmed if someone remains a citizen while the case is being litigated. Isn't that literally what they just laid out Nken is, right? The Nken is the standard by which, like, that things are immediate and that if the shadow docket injunction is not, like, granted, that immediate irreparable harm would be done. But, like, isn't that the whole point of Nken? So it's so weird for them to say they discussed Nken, but then they brushed off the whole irreparable harm part. Well, isn't that like kind of what Nken is? And then that the core of it? I don't know. It's just very strange. That was wrong. When Nken should have required Trump to demonstrate why these Americans couldn't just be stripped of their citizenship at some latter date if he somehow prevails in this litigation. In any event, restoring Nken would address Kavanaugh's concern about hastily drafted opinions in nearly every case. If the court started applying Nken to Trump, most of his shadow docket petitions would simply be dismissed for seeking relief prematurely. So there would be no need for the court to issue a rushed opinion explaining whether Trump is likely to prevail once the case is fully litigated. If Nken were still applied, the risk that lower courts would then be bound by those rushed opinions would also disappear in most cases because there would be no opinions. There would still be occasional shadow docket decisions blocking a lower court's order, like the court's very brief order in the mifepristone case, where the justices blocked Kaczmarski's without fully explaining themselves. But those decisions would be rare. There would no longer be more than a dozen decisions handed down in just a few months, all of which favor a Republican administration, and few of which contain any legal reasoning whatsoever. I think there's a good reason why they're not explaining all this, right? They are, The Supreme Court justices are not stupid, right? They have spent decades and decades studying law and getting to the point where they are. And they are very well aware of the Nken standard and how it exists. And I think they're very strategically not discussing it and not bringing it up in public and sort of like quietly changing the rules and disregarding the precedent of Nken so that they can basically reapply it later when a Democrat comes back into office. And this is the perfect way they can do it, right? They never officially killed Nken. They just sort of slyly, without saying anything and acknowledging it, changed the ways and the rules that Nken works. But then as soon as, Newsom or some other Democrat gets elected after Trump, or if a Democrat gets elected after Trump, that they're immediately going to go right back to the old Nken standard and pretend like they never went away from it, and they'll just completely ignore all the cases which they didn't, and anytime anybody asks about it, they'll call them ridiculous or they'll just dismiss the question outright. This just seems like a perfect way for them to be super politically biased and is like complicated. And like, imagine trying to explain the concept of the shadow docket and how all of this works to your, barely politically interested uncle, right? It's just far too complicated for most people to like, it's really in the weeds. And in that sense, it makes it the perfect corruption vector.